Hi everyone, welcome back. In today's lesson, we're going to go ahead and talk about precedent court cases. I know you're already thinking to yourself, I don't know what a precedent is. Well, guess what? We're going to talk about that as well. We'll define the term precedent and what it means when we talk about Supreme Court cases. We're also going to look at two very important examples, so make sure you're in your interactive notebook and you're following along. Okay, we're on page 7 of your interactive notebook. And let's first and foremost define what on earth is a precedent. So a precedent is a fancy term meaning something that precedes or comes before. When we talk about the Supreme Court and Supreme Court cases, this is something that they rely on in order to make later judgments. So these are usually earlier laws or decisions that provide some sort of an example or a rule to guide them in the case that they're actually deciding. A great example of a precedent, to put it in terms for a teenager, would be, let's pretend you have Friday night plans. And you said, Mom, Dad, hey, can I stay out can curfew tonight be 10 o'clock? Mom, Dad says, okay, all right, 10 o'clock, you're home on the dot, way to go, good job. The following week comes, you say, hey, Mom, Dad, can I go out Friday night, stay out till 10 o'clock's my curfew? And Mom or Dad says, nah, 9 o'clock. And you say, whoa, wait a tick. But last week, you let me stay out till 10. I was home on time. Why can't? The precedent was set. 10 o'clock is your curfew. So it's something that guides you as you go along. You might have heard the word precedent a lot this year if you're watching this in 2021, because the year 2020, with the COVID and all the craziness that's been going on, the word unprecedented has been used so many times. So if something is unprecedented, that means it's like uncharacteristic. It hasn't happened a lot before. So precedent is the exact opposite. It's the idea that it's something that's happened before and we use it as a gauge or a rule or an example. So now that we know what a precedent is, let's talk about how the Supreme Court, which is the highest court in the land, remember we have 3 branches of government, the executive, the legislative, and the judicial. The Supreme Court rules over the judicial branch, but they have this power known as judicial review, and that is kind of what helps them use precedent court cases. The concept of judicial review was created by the court case of Marbury versus Madison. We are not going to get into that here. I am going to link down in the description a link to a kind of quick and dirty version of Marbury versus Madison. If you're interested, go check it out. So anyway, judicial review basically allows the Supreme Court to declare the actions or acts of Congress as constitutional or unconstitutional. So they can rule on different laws, rules, examples, cases, Supreme Court decisions, and they can say, okay, they can review it and say it is constitutional or it's unconstitutional, going against the Constitution. This sets up and allows for checks and balances. And again, you'll remember with those 3 branches of government, our government was set up that each one wouldn't have more power than the other, and certain checks and balances were built in so that one branch, again, doesn't become more powerful. Judicial review is one of the biggest powers that the Supreme Court and the judicial branch have in order to check the other 2 branches. So court cases in the Supreme Court, there's more than 7,000 applications for cases to come across the Supreme Court's desk. The Supreme Court doesn't have time every year to see 7,000 cases. So in actuality, they usually only hear less than 200 cases a year. So that is a crazy statistic to see 200 out of 700, 200 out of 7,000, I should say, a year. So that means if you are going to get something to the Supreme Court, it's going to be something super special. Usually what they hear, they select cases that involve important constitutional issues, something that's going to affect the entire nation. Again, it has to be something that's pretty special. And so let's talk about 2 different cases that made their way all the way up to the Supreme Court. And we're also going to talk about how one becomes a precedent for the other. And then the other sets up a precedent for modern times. So our first court case comes in 1896. It was Plessy versus Ferguson. If we back up a little bit and talk about some of the background of the court case, it takes place in Louisiana. Louisiana had set up a law known as the Separate Car Act, and that basically allowed the railroad company to have separate but equal train cars. Train car for blacks, train car for whites. As I'm sure you've guessed, the black train cars were not as nice as the white train cars. So a group known as the Free People of Color in New Orleans decided to make a cause to repeal this law, to show that it was unjust, that it's not constitutional, that it goes against their rights. One of their members was this gentleman pictured here, Homer Plessy. He was actually 1/8 black, so 7/8 whites. He's, one of his, great grandparents was actually black, but in the time of Jim Crow, in the time of segregation, this time period, the late 1800s, if you had a drop of black in you, you were considered black. He appeared white, but again, people knew that he had black in him. They decided, he said, okay, I'm going to go. We're going to test the system. He got on the train, sits in the whites only rail car. Now, it wasn't a fact of, the guy walks by, is like, oh, you look black, I can tell. The train company had been tipped off, basically. And so they knew he was coming, and they knew he was going to be in violation. So that's why they ended up arresting him. So he refuses to move to the blacks only car, says, nope, I'm going to sit here. The black car is inferior, whatever. And so he's arrested. He goes on to sue the train company, and then it makes its way all the way up to the Supreme Court. Plessy argued that act, the Separate Train Car Act, violated his 14th Amendment rights. He's a natural-born citizen, lives in the United States, should be guaranteed all those rights. The Supreme Court, unfortunately, disagreed with Plessy. They said separating races didn't take away from civil or political rights. There was one Supreme Court justice who's pictured here, Justice Harlan. He was the only one to dissent. If you dissent in a Supreme Court decision, that means you disagree. You go against the majority. He said our Constitution is colorblind, so it doesn't see black or white. And he says that the court's decision, the Supreme Court's decision, with the Plessy versus Ferguson case, would lead to racial hatred and increased attacks against black people's rights. I think he was right. So this sets up the precedent for separate but equal. This clause comes out separate but equal. You would have separate facilities for blacks and whites so long as they were equal. People go throughout history into the 1900s with separate facilities, separate water fountains, separate buses, separate places to sit in a movie theater, separate places to sit in a diner or a restaurant, separate entrances for anything. Everything was separated, separate schools. And so that's the way life was set up, because this court case said it was okay, said it was constitutional. Fast forward to 1954. Schools, as I said, were segregated or separated by race. They had schools for black children, they had schools for white children. Again, the precedent had been set up by Plessy versus Ferguson, and it said that segregation was constitutional so long as the facilities were equal. 9 times out of 10, the facilities for black children were not always equal. So the NAACP and black families or black parents started to band together and said, look, this precedent is not working. We want to challenge the Plessy versus Ferguson decision. We want to get rid of that precedent and set up a new one. One of the most famous families that works with the NAACP was the family here, Linda Brown. Her dad, Oliver Brown, he tried to enroll her into the all-white public school that was closer to her house, and they said no way. Another thing to mention is a lot of times these schools, they might have been inferior for blacks, but also it could have also been that the school for a black child could have been like across town. Like Linda Brown, I think she had to literally walk like 7 miles when she actually had a school that was about a mile away from her house. So I mean that it didn't make sense that why does she have to go all the way across town just because of the color of her skin? Why can't she go to the school that's like literally right down the street from her house? So that was another reason. So these families argued They had a collection of different cases that went along with this. Just Linda Brown kind of takes precedent on it. Her name goes through at the top. There was actually Delaware was thrown into this court case as well, with Howard High School. But they argued that segregated public schools were not equal, and again, they violated the 14th Amendment. This time around, the Supreme Court agreed with the Brown family in this court case. They actually reversed the Plessy versus Ferguson court case. They got rid of the whole separate but equal doctrine, and they said separate but equal had no place in public education. It was not right. And I actually looked at this court case when I was in school, and I always thought that they said this because, facilities and the teachers and all that, it wasn't equal, and that wasn't fair. It's not nice for these two kids. But actually what one of the justices wrote is here on the screen. They said that separating children just because of race, quote, generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way that are unlikely to be undone, unquote. The idea of it's not that, oh, they have nicer stuff than us. It's the fact that you're separated. You're put over there because you're not worthy. You're not good enough. You're inferior. That was going to play on the minds of these kids. That is why they said this cannot be done anymore. So more power to those justices, and thank them, because that is why we have non-segregated schools these days. Now, it wasn't something that people got over with that day. There was still extreme prejudice. There were still people who wanted segregation. There were places that would not let the schools integrate or mix the races. It takes a little bit of a while. Again, the civil rights movement helps with that. But it became federal law that the new precedent is that Black and white children can attend the same school. So again, you want to think of this as this is the precedent for today, why many of you, black, white, purple, green, blue, whatever you are all in the same school. So again, this video and our last video here has been talking about precedent court cases. Again, a ruling that sets up an example or a rule or a law that guides future court cases, or a way that you can look back on them. So again, make sure this is in your interactive notebook. Thanks for tuning in, and check us out for our next lesson in the next unit. Thanks for watching.